Thank you.
SJC-11472, Commonwealth v. Tari Richardson.
All right, let's proceed.
May it please the court, William Adams for Tari Richardson. Since we closed in the last case on the case that was paired with this, talking about the sentence enhancements, I thought I may as well open with that. In this case, it's different from that case, obviously, which involved the classic habitual offender statute. In this case, we have two progressive schemes which impose heightened penalties upon commission of types of offenses. One is a standard repeat offender provision having to do with unlawful possession of a firearm. The other one, which is likewise triggered by a conviction for unlawful possession of a firearm, has to do with whether or not there are prior convictions for a violent crime or for a drug offense of some kind. So aside from the fact that they have the same starting point, which is the conviction for unlawful possession of a firearm, we don't have the dual use issue, which was referred to earlier in the argument. It's our contention, basically, that these are irreconcilable and that one has to be picked. And I've discussed in the brief why stacking them won't work. And I'll address any points regarding that, but I think I laid it out as clearly as I could.
Who picks?
Well, I think really we need a decision from this court saying we're going to apply these rules because these problems are going to come up again and again. This is not going to be isolated. And there are various ways of looking at it. One way could say, well, if we determine that they are irreconcilable, whichever has, and I'm drawing on an old case called Commonwealth versus Cerveny, Cerveny. It was overruled on another ground in Crocker. But the principle in the case was the Commonwealth is entitled to, in that case, they had to do it with offense, but the offense which has the greatest maximum possible sentence. So that's an objective rule, and that's what we're going to do this. I'm arguing, and that's one way of going at it, I'm arguing that, in fact, if you're actually dealing with the repeat offender provision, that you should go with the repeat offender provision simply because it's more specific and it reflects, the legislature's judgment about when you commit this crime over and over again, this is what's going to happen to you. And it's tied in with the whole notion, of sentence enhancements, which, once again, it's a legislative determination. If we have someone who does these offenses over and over again, this is what we deduce about that person's mental state. They do these things. And that's what the offense is going to be. I mean, that's what the result is going to be.
But the Commonwealth has to prove these by offering evidence with regard to the enhancement, correct?
I'm sorry, Justice.
The Commonwealth has to prove the enhancement.
They do.
So if it turns out that you are right and you can only choose one of the enhancements, why can't the Commonwealth simply prove only one and not prove the other?
They could.
So the
Could just
Commonwealth
say,
has the
we're
ability
going-
to
we're going in
essentially...
on- We're going in on this one.
And we're not going to offer the conviction into evidence that would prove the second or the other enhancement because it's less favorable to
It's
us.
an option that they have. It's just the same kind of decisions made. How many offenses are they going to indict for or file a complaint for? I mean, that's the kind of discretionary call.
But when instructing the jury, we use that language from, I think it's the Dickerson case. The Commonwealth is entitled to a conviction of the highest crime that it's proved. If the Commonwealth has earned the conviction, why shouldn't they be entitled to pick? They might even pick the lesser for any number of reasons.
I think the first difficulty is, would that be what the legislature intended? Did the legislature actually want to have that kind of discretionary authority bestowed on the Commonwealth? Is there evidence in the statute that would suggest that? As opposed to just deciding what offenses you're going to go with and what you think you can prove or what's easiest to prove or best serves the purpose in the situation. And unless the statute says the Commonwealth can opt, I think, once again, it becomes a question of law for the court. And complicating factors are things like if there are minimum mandatory sentences, which are different, as they are here. That lends some weight to the idea that the Commonwealth has made a determination that that one course will be preferable over another, rather than confiding it to anyone's discretion, because we, the legislature, decided that discretion is not applicable, at least up to this point. So that would be another consideration in the case. I'm sorry, I lost my track on this. And the underlying premise for what I'm saying is basically that it's basically due process. Statutes have to be clear about what's going to happen. What are the consequences of your conduct? And if the Commonwealth, and it's therefore the legislature's duty to be very clear about it, or as clear as they can be. And where they are ambiguous, and I think this was the point Mr. Vandersloot was making, then if there's an ambiguity, then courts do, as they always do in those cases, fall back and sort of standard accepted rules of construction. And I've laid them out in my brief. I won't have to go over them. You know them better than I, or as well as certainly. And in a situation like this, where you have two statutes where neither refers to the other, both are sort of self-contained units about what happens and how it's done and so forth, and they can't be reconciled in any way and come up with one sentence which incorporates all the facets of them. I think the court has to come up with a rule of some kind to decide what we're going to do in that situation. Looking ahead, as I may say, to other cases where this is probably going to come up. One of the bedeviling aspects about this is that, although I know we say things like the legislature is presumed to know what's happened or what they've done or what the decisions of this court are, so forth and so on. The difficulty is, I think these statutes, when they develop, sort of develop on a track. They don't necessarily, there's not necessarily a reference, even a conscious reference in the legislature's mind. Well, if this situation comes up, this is what's going to happen. I think this comes into the category of an unforeseen exigency. They just weren't thinking about this, because I think if they had thought about it, we would have had some indication somewhere in one of the statutes, because we do it all the time, except it's provided in section such and such and chapter such and such, the following takes place. And now, increasingly, when we're moving in directions like we have this corpus, as it were, of legislation pertaining to drug offenses, this corpus pertaining to firearm offenses and so on, where they are so highly intervolved and interrelated, it seems more and more that it would be fair to say to the legislature, this is how we're going to decide these cases. If you want to put it in the statute, I mean, it's putting it a little bluntly, but if you want to put it in the statute, how this is supposed to happen, that's what we should do. But this, in lieu of something else coming up, this is what we're going to do. And that's why I suggest, I think you have to look, Justice Spina alluded to it, you have to look, in a sense, you have to look to some external rule which is going to make this possible, both to provide guidance to the trial court, to litigants, and at least theoretically to prospective criminal defendants. I will make another point, too, because it has been coming up. It's not really an issue here because the Commonwealth has abandoned it. But it's a mistake, I think, to look to Morey. The way Morey developed historically and so on has really nothing to do with sentence enhancements at all. And it's also a mistake, aside from the fact that if you're relying on the rules of construction and just the general approach and so on, it's a mistake to look at cases, if I may say so, like Hawkins, because in cases where there's an enhancement, the typical example is a firearm enhancement. If the firearm is used in the commission of a felony, this happens and so on. But then it turns out that the substantive offense itself has provision for a firearm. The theory in those cases really is that the legislature has already taken into account when it defined the offense that a firearm was used. So then to add that to it when it's already been used to define the crime, and presumably to establish whatever the penalty is for that crime, it's redundant in that sense. In other words, it's...
I gather the crux of your argument, and tell me if I'm wrong, is that under Bynum and Johnson, I think it is, there's a single judgment, which includes a felony and the enhancement.
That's correct.
And that what the court did here essentially were two judgments, with a felony enhancement 1 and a separate, and the same felony enhancement 2. And you can't do that. There's only a single judgment, and you got to choose one enhancement.
That's it, yeah, basically. Yeah, the court, it's not really clear. What happened was there was a major offense, which was the assault with a dangerous weapon with intent to murder. And then the one conviction for unlawful possession of a firearm, and then imposed two judgments on that, based on the fact that there were two enhancements, and even made them from and after. They were concurrent, but made them from and after the major sentence in the case. So the point is exactly as you say. We need one judgment, and the question is, what rule do we use, or what do we invoke to get there? I think that I've read, I would say, conservatively, at least 40 cases in other jurisdictions, probably many more. There's no set way courts go about doing this. There are some general tendencies. It's not in this case, but the dual use of a conviction to enhance under separate statutes. Some courts have said you can't have that. You can't, for example, use the same possession of a firearm to trigger a habitual offender statute and a repeat offender statute, or to elevate one offense so it then fits into the general habitual offender category. But the legislation, the penology that's been developed in other jurisdictions, especially like California and so forth, it's just too elaborate. We really, really have to make it a homegrown type thing. That's one of the reasons I'm suggesting if we look at Cerveny, where it says, the Commonwealth is entitled to whatever the offense was that had the highest conviction. By analogy, then you would say, then that's what we'll do with sentence enhancements. Other things will fall by the way, because if as here they have different mandatory minimums, then in a sense you're frustrating legislative intent if by applying that rule you're actually giving the judge more discretion to impose an indeterminate sentence because the mandatory minimum is less. But as I say, I don't think that there's any other good way of reconciling things. It's just not workable. I couldn't find a single way of making it happen.
But what's to prevent, if I understand your theory correctly about it should be the lower sanction, the enhancement that should be selected. What's to prevent a prosecutor during trial who sees the case going pretty well from not putting in that certified conviction of the lesser enhancement?
I think the prosecutor can do it just as it can null pros. It's that kind of thing. The question, I may not be getting your point, Justice Spina. I'm sorry, because I'm not. The prosecutor can, of course, null pros. He could opt not to introduce evidence, whatever we want to do. What we're looking for from this court is a rule that would address situations, let's say, where everything goes in. I mean, it's analogous to over-indicting, where you have several indictments. There are actually 3 substantive offenses because of lesser included and so on. You might end up with 7 indictments. They could start out that way, but knowing, in fact, that when it comes to a judgment, this is what's going to happen. I mean, depending on what the evidence shows, what the verdict is, and then what prior convictions are proved. And I'm running out of time here. The one point I did want to make is I would like you to pay very close attention, if you would. I'm not suggesting you don't otherwise, but to the sentencing colloquy and so forth and so on. And the reason I'm suggesting to that is because I think this is an appropriate case for the court to remand to the judge to vacate the sentences, both of the sentences, both the assault with intent to commit murder and the unlawful conviction, and resentence, simply because there was so much confusion about what actually was sentenciable and what should be happening and so forth and so on. There is authority for that, Commonwealth versus Clermy, C-L-E-R-M-Y, it's in 421 Mass Reports. And the reason it's also a problem is this case went up to the appellate division on the assumption that there were 3 judgments, and they ruled based on 3 judgments. And I think in order to have jurisdiction for a remand, I think for the purposes of the appellate division, I don't really know, there's no law on it, but I think there has to be a fresh sentence. And it seems to me that this would be an instance where, because there was confusion, there should be resentencing, and then, if possible, take it back up to the appellate division.
Thank you, counsel.
Thank you.
Good morning, if it please the court. Gail McKenna, Assistant District Attorney for the Commonwealth. I have to disagree with my brother that we do in fact have a set way of looking at our statutes in the Commonwealth that's been in place for 130 years and that works perfectly well in this case, which is Commonwealth versus Morey. We look at the elements as a matter of statutory construction, and if we have different elements, that's what we assume that the legislature then intended to allow us to charge different crimes. Now, I understand here we're talking about sentences, but after Bynum was decided, the Supreme Court decided Apprendi. And what they said in Apprendi is that every fact or, fact and element are used interchangeably in double jeopardy law, and that extends here, that every fact had to be proven to a fact finder, and that's what we're doing here. So what I would suggest is that that law is perfectly applicable here in saying that, yes, in looking at the legislature's intent under Morey, which is our established law here in Massachusetts, that was then adopted by the Supreme Court in the Blockberger case, that this is the way to look at these cases.
But Murray's focused on the elements of a crime.
Correct.
And Bynum says a sentencing enhancement is not an element of the crime. It is separate and apart from the crime, but it focuses on the issue of what sentence is possible. Why would that not distinguish it from Morey?
Well, what Bynum also says is that a single judgment is appropriate. So what I'm saying is when we're looking at what that single judgment should be, and when we're analyzing that sentence and what sentence enhancements are appropriate, that we look at the later decided case of Apprendi and deciding what the potential elements of the sentence can be, and that's the appropriate analysis, which is Apprendi, which essentially adopted the Morey analysis, the Blockberger analysis, and looking at elements in sentencing.
Well, but I mean, so is your view that there can be 2 judgments now?
No, I'm still saying there's one.
One judgment.
One consolidated judgment.
With 2 separate counts and 2 separate sentences?
With a consolidated sentence. And this,
What does that mean, consolidated? Does it mean that there are 2 sentences or that there's 1 sentence?
one sentence, one punishment. And the punishment would be of the higher of the 2. We would have to prove both, or either. But when the judge went to sentence, he would sentence on the higher
So you would say
number.
you would choose?
No, and I don't think that he has to choose. We're talking about
But you would choose, the
sentencing.
prosecutor would choose, I assume.
No, we would still prove both. If this
You would choose, you would essentially move for sentencing on the higher enhancement, right?
Well, you know,
You
the
can only,
reason that
you
we-
can only get one enhancement. Do you agree?
No, I think we're entitled to both enhancements.
So if one you mean so you add them together? Is that what you mean?
Yes, well, I think that it has to be a consolidated sentence. It has to be one sentence, and how are we going to do the consolidated sentence? And I think I'm on firm ground on that when I look at the statute, and let me just grab this.
Well, let's,
When I look
give
at-
us an illustration
Yeah.
of numbers.
Yeah.
I will. Here, what happened was that I had, and the judge here ran them concurrent. That's how he tried to do the judgment. And the problem here is with the minimus. The minimus wrote this out like it was two separate judgments. The judge only.
Just give us some numbers.
Sure. We have here a 5 to 7 and a 3 to 15. The judge's discretion would run from 5 to 15, and he would be somewhere in the 5 to 15 range when he enhanced the sentence. So that the two together would set what his discretion was in doing the sentence. And I don't think that's a problem when you look at 278.11a, which sets out the procedure here. The last line says, upon the return of a verdict after the separate trial of the issue of the conviction of one or more prior offenses, the court shall impose the sentence appropriate to said verdict. I mean, that's at the end of the entire procedure. It's the sentence appropriate to said verdict. And the verdict would be on the aggregate of what was before them. I mean, my problem with us selecting out is the same problem that happens when we try a manslaughter, motor vehicle homicide, negligent driving. We're then up at the appellate court on all three, or the same thing on a felony murder with an underlying felony. Those stay in place, and the reason they stay in place is if there's a problem with insufficiency of evidence or another problem with the verdict. I mean, we can't be in a position where we're doing our best, we have legitimate charges that the legislature lets us bring, and then we're in danger of having them vacated on appeal. And, you know, we're in the unfortunate position of having to have made this Hobson's choice at the trial court, where we've had to remove from the consideration of the judge a charge that's legitimately in front of them. And we know it's legitimately in front of them because we have this entire Maury test, and we also have the consideration that we know the legislature, we know that from the Hawkins case, when they want to specifically exclude something, they do it. And we cannot impose on the legislature a regime where every time they want to exclude something, they have to have an exclusion list. That's not how we ask the legislature to write law. It would just be chaotic. Instead, what we assume is that when they want to exclude it, they will. And they did in that Hawkins case that's cited in many of the briefs that's before
Was
the
there
court.
one indictment with multiple counts here?
Yes.
So what if there were two separate indictments? Would you have one sentence?
We wouldn't have two separate indictments.
Well, if you could if you wanted. And what if you did?
Then it would, under Bynum, we can only have one sentence. I mean, what we had here, Your Honor, is that we had an appropriate indictment. We had an indictment.
So what would the sentence look, what would the endorsement on the back of the indictment look like in terms of the sentence that was imposed if you had two separate, indictments?
I think that what we would have to do in order for the minimus to look right and for DOC to accept it is to have the sentence enter.
The minimum, basically being the minimum mandatory and the max being the ceiling.
Right, on the enhancement with the highest crime charged.
But the enhancement on the highest, but the sentence would only be on the highest crime charged.
Right, and it's the problem we're running into is a difficult procedure in presenting this on the minimus so it goes properly to the DOC so they can administer this, and keeping all of the convictions in place till the end of the appellate process. I mean, those are really what the two problems that we're having here. It's not a problem with what the legislature intended. They clearly intended this, or they would have said otherwise. We know that. That's how legislation works.
Okay,
As I said, otherwise it would
help me
be
to understand. With regard to the 10D,
Say again?
with regard to the 10D, the section 10D,
Yep.
minimum mandatory is what?
3 to 7,
So it's a minimum,
5 to 7,
so it's a minimum of 5 and a maximum of 7?
right.
And with regard to the 10GA,
3 to 15.
the minimum, so you basically, what you're wanting to do is to take the higher minimum mandatory and then the higher max. You want to sort of get a mix in,
5 to 15, right.
so you want to mix them with the
Essentially,
higher,
yes.
so that's why you don't want to choose, because you want the higher mandatory of the first,
Well,
the
I
higher
think-
minimum mandatory of the first, and you want the higher maximum of the second.
And I think that that's what the legislature intended.
And that sentence can only survive on the conviction of the highest offense. You couldn't have that
Yes.
sentence on the lower one because it didn't have this,
Right.
the upper level was not sufficient.
But the problem with the 3 is that it doesn't take into account what the legislature intended on the other enhancement.
But you can still impose the minimum, it doesn't appear as a minimum mandatory, but the numbers fall within the statutory range of punishment.
Right, but the legislature's taken away the judge's discretion there on what it wants a judge to do in particular circumstances. And, you know, the 10D is the multiple firearms. That's been in effect since 1967. I mean, there's nothing new here as far as enhancing sentences
So
or
how-
having stronger sentences for guns.
How would this work? If you say there should be a single consolidated sentence of 5 to 15, how would and that sentence would be imposed on the 10GA, the one that carried the 15 max?
You know, and this is my problem, and
I see it's a problem.
it is. And
But
you know, and
actually what
I'm
you-
candid about that.
But what you would do was, it seems to me, if you had two indictments, you would have two minimuses, I guess, and one had a sentence of 5 to 15, and the other one had a sentence of 5 to 10.
Well, you know, I can ask you to overrule Bynum. I mean, which,
And let it go up on appeal and let the dust settle on appeal if there's an appeal.
well, and that would be consonant with what the court does on other similar situations where that happens. But, you know, it wouldn't be completely unfair for this court to overrule Bynum either, and say that, you know, what is fair and appropriate here based on the legislative language is to have two sentences. One that takes into account what happens when someone keeps using a gun, and one that takes into account when one is a career criminal, which is what the 10G is. I mean, we have this Bynum, it's a common law rule, and there's nothing that stops this court from adjusting it to comply with the legislative intent in its underlying statutes. And I can see Judge Botts that doesn't like that argument.
But you agree you could not do them consecutive?
I don't know what would prevent a judge from doing it consecutive. I
That's,
don't know what.
then you're in a different ballgame. I mean,
I
it's one thing to
am.
say you want to mix and match. You want the benefit of the larger minimum mandatory and the larger max. But once you begin to go consecutive,
I know Judge Gantz, but I don't know what in the legislation prevents me from making that argument. I don't know what in the law prevents me from making that argument. I don't have a constitutional prohibition. I don't have a statutory construction prohibition. I mean, the only problem here is a problem with writing out a MIT. I have a statute here, 27811A, that just says impose the sentence appropriate to the verdict. Why isn't the sentence appropriate to the verdict the one that takes into account that you can from and after these within a sentence?
but then it's two sentences.
No,
And you've
it's a
said,
consolidated sentence.
well, I mean, effectively, it has to be one sentence followed by another sentence. You can call those two consolidated, but they're still two sentences if they're on and after.
I think it's one consolidated sentence based on the legislative intent that someone who carries multiple guns and commits multiple violent crimes is treated in a particular way.
But you know, if you are right, the judge would have to say, as to Section 10D, I sentence you to 5 to 7 years, and as to Section 10GA, I sentence you to 10 to 15 years on and after. So there'd be two separate sentences, one to follow the other.
Right, and again, we're dealing with a procedural issue, not
Well,
with a substantive
it's not a
issue.
procedural issue for the defendant.
Well, we're dealing with the issue of what it's going to look like. We're not dealing with the issue of substantively what the judge can do as far as the sentence is concerned.
If you're speaking about consecutive sentences, though, that changes the potential maximum.
Right, and here I am today, I'm here with a consecutive sentence. So.
But you're here with the
the next-
concurrent.
Current.
I'm sorry, concurrent, yes. Mix that up. So the other is a hypothetical as far as my case is concerned. I think I win that argument too, but I only really have to win the case in front of me, and I would like to, so I'm going to respectfully ask, since the yellow light is on, that you affirm what Judge Locke did below, but that if necessary, that it come into one judgment. And that's what we would be looking for, is for, if the court isn't to overrule Bynum, to have it be a single judgment.
And that single judgment would say what in this case?
I think the single judgment would say that it was a sentence, I think it would say under 10D and 10GA with a, well, the judge here put it at a 6, and the top would be 10, so it would be the 6 to 10. The actual sentence was the 6 to 10. And I would thank you all for your kind attention and respectfully request that relief.
Thank you.
Thank you, Counsel.
Thank you all.